में गांठ है तो संधान भी है, हर सिक्के के होते हैं दो पहलू, जीवन में अगर समस्या है तो समाधान भी है, समाधान भी है। Thank you very much. More of these conferences are lined up. As said, we'll be finishing our tenure on 24th Feb. Oh yes, one of the most remarkable things that we did, and let me, sir, just take more 5 minutes now. Most of you were part of it, because when we hosted something in Goregaon, one of the largest conferences, I think the element was missing there, but I thought let me cover it very well. We could do something extraordinary. We could do something extraordinary, and believe me, to do this extraordinary, there are two things that helped us a lot. One is collaboration, the efforts of everyone, and the second is one divine intervention that we always seek, we always look forward to, and believe me, it is always there. Starting from the conference, the theme, the 37, if you will see our conference, 37th regional conference, the 37th turned out to be like a Om. If you will see that, that was one of those symbolic experiences of how it happened so well. Second, when we thought about Chaitanya, Chaitanya is a theme. Believe me, we were fooled by Google to give this conference, this theme to us. And you will be, if I were to just share with you in the next 2 minutes, you will feel absolutely shocked the way it happened to us. All of us were in our chairman office and we were looking at what should be the theme of our conference 3 months before this conference, 15 December. Avinash bhai, welcome. And then we Googled various names. What should be there, what should not be there. And immediately we thought, what is there on 15 December? Let us search that. And we Googled what kind of day, जैसे कल youth day था, entrepreneurs day था, ये सब बहुत सारे days रहते हैं आजकल, वर्ल्ड में हर कोई डे बना रहा है, हिंदी दिवस भी गया, तो हमने सोचा कि 15 दिसंबर को भी कुछ होगा, तो we did Google 15 December, it came as International Consciousness Day. We were in chairman chambers, 5 of us, Ketan bhai, Saurabh, Rankit, Gautam, all of us were there. We thought, okay, Consciousness Day, चलो इस पे कुछ बनाते हैं. Consciousness से आ गई चेतना, चेतना से चैतन्य, और राम आएंगे सब चल रहा है, तो हमने भगवा रंग भी भर दिया उसमें, तो हमारी पूरी मशाल वशाल बना दी चैतन्य के ऊपर, पूरी ड्राफ्टिंग हो गई. See, understand, all of these brandings have been done using AI. We have a in-house person who does this for us, and we ensure that no one can come and claim that ये हमारा logo है, no one can मतलब लीगल सूट कोई फाइल ना कर दे, प्लेजरिज्म कोई फाइल ना कर दे, तो हम लोग इसमें थोड़ा चेंजेस करते रहते हैं, तो इसलिए वो चैतन्य का लोगो बन गया. 3 days before the conference, MOCs came running to Ankit and Saurabh and Ketan bhai that बॉस आप लोग क्या बोल रहे हो, चैतन्य कॉन्शियसनेस क्या है, क्यों है, 15 दिसंबर को क्यों ऐसा है, आपने बोला स्क्रिप्ट में लिखो, पर ऐसा तो कुछ है नहीं. They were shocked, क्या है, क्या बात कर रहे हो. They came to me and told me, chairman, there is something different happening. बोला what is it? बोला it looks like your computer is bugged. बोला why? बोला sir, there is nothing on 15 December. बोला what are you saying? Again on the same computer, I was there on my chair, all of us same together. We fired up Google. We asked what is on 15 December, and there was nothing. It didn't show up anything. We then searched what is international consciousness. There is no international consciousness there. There is International Conscience Day, which is on 5th April. I'm like, what has to be done on 5th April? That my tenure is over then. But believe me, there is one power that gave us that Chetna in that day. And that is why Chetna was gifted to us by one that power. And when all of these happened, first day, 2,500 people, first time ever. 1200 के ऊपर कभी regional conference में आए नहीं है WRC में. Although WRC is the largest region, so many people, but मुश्किल से लोग आते हैं. And so therefore गोरेगांव में 2500 लोग, all of us in that conference, from bare shell, 52 feet long stage, highest ever, the longest ever. Startup, Glowpack, World Congress, all of that, and our conference was one of, and not one but 2 conferences together. We did this. First day our engagement went from 10 a.m. to evening 10 p.m. because all of हमारे एक कवि जितने भी आए थे चार्टर्ड अकाउंटेंट स्टूडेंट्स को देख के वो भी कविता में नहीं, वो तो एकदम स्टार्क उसमें चले गए, डार्क ह्यूमर में चले गए, रियलिटी ऑफ लाइफ में चले गए. एंड दोस सेशंस आर सो एंग्रॉसिंग, इट वेंट टिल 10 p.m. सो 12 hours वी हैड एन एंगेजमेंट इन द फर्स्ट डे. यूजुअली ऐसा होता है कि सेकंड डे पे कम हो जाते हैं लोग, जीएसटी था नहीं हमारे पास टॉपिक, मतलब बिमल जैन साहब थे, पर फिर भी वन ऑफ द मोस्ट आइकॉनिक सेशंस दैट वी ड्राफ्टेड वाज द enactment of how does a GST investigation takes place. The artists are here. I will not say chartered accountants or, but the directors, the artists, all of them are here. I think huge round of applause for Saxena sir, Thakkar sir, and Laddas ji. One of those conferences that has gone ahead of time anywhere, everywhere. You know, real enactment of how does an investigation happens. मतलब dialogues क्या, delivery क्या, real. There was an inspector also. और सब कुछ बना दिया था, but that was really very engrossing. And there was the toughest task of taking all the people out to make a world record. And this is what we could do with the help of the Almighty and a divine intervention. Yes.
Now I am become death, the destroyer of worlds.
This piece of work where we made a human mosaic, 5,030 people came together. 5,030 people came together to set up, hold a 2x2 placard on their heads, make an ICI, to make sure that एक विश्व का सबसे बड़ा ह्यूमन मोज़ेक बनाने का रिकॉर्ड भारत को मिले, और भारत में आपकी और मेरी, हम सबकी WRC के नाम वो रिकॉर्ड अर्जित हुआ 16 दिसंबर को, with the help of all of you. So this is what happened at 16 December, and all of us today are the proud holders of this world record, the ICI. Thank you very much, whoever was there in this part. We just got a certificate yesterday. जैसे ISO certification होता है वैसे वो provisional उस समय था, IUDX का पूरा audit करके ये करके, so 107 rows, 49 rows, 107 people in each row, plus so many 100 volunteers, सब कुछ मिला विला के they made this combination, and yesterday we've got this certificate confirming that you are the owners of this world record. And from Jeddah to India, now we are the holders of this 5,032 people together. It all was possible because of each one of you. Thank you very much for being with us, and look forward to have you more, 1.5 months more. 25th this January I invite all of you. S. Vaidyanathan Iyer Memorial Lecture होता है. We've got राज दीदी राजेश्वरी मोदी जो ये करती है, नारायण रेकी करती हैं. She is gonna talk about some approach to life for a happier life and all of this. One such session. I invite all of you again. It's happening in Thakur Auditorium, 25th January evening, 5 to 7. Please make sure come with you, with your family if possible, with your spouse, and be with us on that day. It's going to be most of this session. She's most sought after spiritual leader again. So let's come together again and talk about some important things that can really change our life. And with all of you, stay in touch with us. Instagram channels and our emails are the most talked about events now. We are the largest followed accounts on social media in the country, in the ICI, the WRC and Mikasa. Please follow them and see if you have any inputs, suggestions, do let us know. Thank you very much.
Thank you so much, sir. Can I have a huge round of applause for our office bearer for addressing us today? Thank you so much. Now I request CA Bajrang Lal to please escort our speaker for today to the dais. KS Naveen Kumar, sir. Before we proceed and dig down more into GST law and interplay with various other law, let me take this opportunity to introduce our today's speaker. KS Naveen Kumar. He has done BCom, LLB and ML in contract. He has a vast experience of 49 years. He is a practicing lawyer since the year 2001. He specializes in GST and other indirect taxes. He works in litigation and consultation and has appeared before various forums including Supreme Court, High Court, CESTAC, and many more. He provides advisory and representational services in insolvency, SEBI, and commercial court matters. Sir has been office bearer of various association and federation. He has presented paper on indirect taxes including GST. He has also co-authored 3 books on GST and many more. So let us welcome our today's speaker, K.S. Naveen Kumar, with a huge round of applause. Now I request to please present a memento to our speaker, C.A. Bajrang Lal sir. Without wasting much of time, sir, the dais is yours, please.
At the outset, I thank WIRC for inviting me to this national conference, and I also thank the office bearers for providing me the opportunity to address this August gathering on a very important topic, which is interplay between GST and other laws. Because of inclement weather in Bangalore, my voice is a little hoarse, so you have to tolerate my voice for some time. Mr. Gupta was speaking about agreeing to an obligation or tolerating an act. So you may have to endure my voice for some time. Of course, people who are hearing me for the first time would not make out the difference. If you look at this topic of interplay between GST and other laws, this was also included for the first time, maybe more than a decade, in the indirect tax course which was conducted by the ICAI. And it was first organized in Bangalore by Mr. Madhukar. And this was the second topic. So he did not find any other speaker, therefore he put me there. Nevertheless, it is a very important topic because without the knowledge of other laws, our approach to GST may be incomplete. So to that extent, this is a very important topic. As I go on, I am here to share my experience on handling some of the matters where the other laws came to the rescue of the taxpayer while we were agitating matters before the court or tribunal. I'll share a few of them as we go on. So the intent of today's session would be to look at what are the allied laws and what is the importance of it insofar as GST context is concerned, the past instances of litigation, and what are the issues in GST. Of course, the tribunal itself has not yet come. So in any law, only when the statutory mechanism is streamlined with the appropriate forums, then the real issues start coming up. So that has not yet happened in GST context. Now, who is an expert? An expert is a person who knows everything about something and something about everything else. So that is why this topic is there. You are supposed to know something about other laws also. There is one more definition which I have not put on the slide. It is a person who knows everything about something but nothing about anything else. So if at the end of my session, if I inspire you to subscribe to the first definition, then this topic is a success. So that is my attempt insofar as the subject is concerned. The topic is very wide because when you say other laws, it can be any law. So I will be just giving pointers as to how you can look at some of the important laws so that you can start thinking when GST comes. You will not find the solutions only in the framework of GST. Therefore, there is a requirement to look at other laws. Now, what is this allied law? This is how I have attempted to define it. Allied law means anything other than GST law. But it would also include, according to me, legal principles which we have evolved over a period of time, the legal maxims which are all settled, and the judge-made law. So when I say other laws, this is what I am referring to in my session. Now, it would even mean administrative law. It would also cover various judge-made law or case law, or for that matter in the context of GST, even foreign laws can be treated as allied law. Because what is supply? Like what we had in the context of Centlex says manufacture, it took a very long time for the matter to get resolved at the level of Supreme Court. So here also, first of all we should understand what is supply. And I am sure since many other foreign jurisdictions have similar provisions, we may have the benefit of those laws also while interpreting our GST law. Now, why this allied law? To interpret GST, you require the assistance of allied laws, that is other laws. That is one reason. The second reason could be, you cannot look at only GST law and advise someone, because it may have an implication under other laws. I have seen, I will point out as I go on as to how people have looked at only one law, but they have not looked at other laws. To give a small illustration now, you take all these 26 AS related notices which are coming. Most of the time, what I feel is that they didn't look at the GST implication or service tax implication. Someone wanted loan, therefore they showed certain receipts in their P&L account so that a rosy picture can be presented, not knowing that the GST, the service tax department is going to look at these figures because of the exchange of information and data. So now, even as a defense, you don't have anything because they have shown something as receipt. So there may be cases where only one aspect is looked at, but the other aspects are ignored. Therefore, there is a challenge which is faced. So GST also, the similar problem may arise. Now let me start with asking questions from the past laws. I am not expecting you to answer. I am just posing this so that you can think. Under Hindu law, is marriage a social function? That is the first question. What about Mohammedan law? Some people are already thinking, what is this? You are talking about GST and suddenly you have brought Hindu law and Mohammedan law. Answers will come after some time. How those laws helped us to argue some matter in service tax context. When does the right of appeal arise? Any guess? One or two? Does it arise when the order is passed? When does it arise? Small guess. When the order is communicated, while filing returns, right of appeal arises. Okay. Hold on for some time, I will come to that. Whether an engineering firm would include a body corporate. Suppose VAT is wrongly paid by someone. Whether they can say that since I have paid VAT, you cannot demand service tax from me. Or if a person has rightly paid VAT, these type of issues had cropped up in the past. On the goods portion, can the department ignore it and say that you pay tax on the entire value? What is the difference between transfer of right to use and supply of tangible goods? Whether shares before allotment could be called as goods. What is ICU? Certainly not intensive care unit. Now let us look at some illustrations just to generate interest in the subject. I asked you a question, under Hindu law, what is the status of a marriage? There was a service category called mandap keeper, which talked about services by a mandap where they gave the mandap for official, business or social function. This Krishnapur Mutt would give their premises to devotees. They would pay some small donation. The department would say that it is mandap keeper service. And I had only enrolled at the bar in 2001. I was new to the profession. So I was assisting my senior in this matter. Suddenly he asked me to take out Hindu law. I didn't understand what was happening. So he developed an argument based on Hindu law that under the Hindu law, marriage is a religious sacrament and therefore you cannot call it a social function. That was accepted by the tribunal and this case is reported. You can have a look at it. So that was the first time it triggered that knowledge of only the taxation law. Most of the time we are obsessed with that. So we should also increase our peripheral vision so that we look at other laws. Now what happened? This controversy also came up in the context of Mohammedan law, because some people wanted to use this Krishnapur case. Under the Mohammedan law, marriage is a contract. So there is a difference. Then this went on for some time. Since we have a secular setup, they brought in an exemption and said whatever is happening within the religious precincts of a religious premises, we will exempt. I think that entry continues even now. So this is one example where we had to look at some law which was unconnected with taxation, but we got a relief under the service tax law. Now I asked you, when does the right of appeal arise? Some of you who have practiced service tax law would know that there was a provision, section 84 in the Finance Act 94, which talked about revisionary powers by the commissioner. It is similar to what you have in income tax law. But I think in 2009 or so, they removed it and brought it on par with excise law, where the commissioner will only review it and direct the office to examine whether it is legal or proper and ask him to file an appeal. The adjudicating authority himself will file an appeal there. What had happened was consequent to that amendment, because earlier section 84 order was appealable to the tribunal. Since 84, the character of it was changed, that reference to 84 was removed from the appellate mechanism. Hundreds of matters were listed before the tribunal because the department took a plea that they have come to the wrong forum. They should have gone to the High Court by filing a writ petition, because now when they filed the appeal, this reference to 84 order is not there. That is where this issue of maintainability came up, and I had the opportunity of leading the arguments in those matters. So we had to look at section 6 of the General Clauses Act, and because rights accrue because of it, and it is also now tagged to section 174. I will come to that a little later. So our argument in the case was based on Supreme Court judgments in Garikapati Viraya and Hussain Kasam Dada. We said that the right of appeal arises the moment the show cause notice is issued, and I will exercise it only after the order is passed. On that basis, read with section 6, the tribunal came to a conclusion, yes, you are right. Right of appeal arises when section 84 notice was issued. He passed an order, but your right continued, and therefore the appeals are maintainable. So this was one instances where we used the provisions of General Clauses Act to argue a service tax matters, but for it, most of the appeals would have been dismissed on this ground. Now, one more interesting issue. In fact, when I joined my senior's office, Mr. K.S. Ravishankar, who is a senior counsel, in 1997, this was the first opinion he gave to me on service tax. I was a student at the time. If you look at the consulting engineer definition as it stood, it would say consulting engineer means a professionally qualified engineer or engineering firm. Now questions would crop up whether a body corporate would also be covered by engineering firm. Rule of aegis them generis, etc., because it says professionally qualified engineer or engineering firm. So one of the arguments was that body corporate is not included, because when you say engineering firm, it can mean only a partnership firm. Of course, the matter was agitated before the courts. One of the judgment was rendered by Justice Tirath Singh Thakur, single judge, which was later on affirmed by the division bench. They did not agree to this proposition. So here also, just to show the link between other law and the tax law. Supreme Court in iMagic case would say that service tax and VAT are mutually exclusive. Therefore, in a case where you have paid service tax, it should not be subjected to VAT and vice versa. There was one more judgment which came later in Idea Mobile, which the department seeks to use even now when we take a plea. Where there the Supreme Court would say, just because you have paid VAT, that does not absolve you from the liability under the service tax. But what is missed out by the department is the factual position that in the Idea Mobile case, the party had wrongly paid VAT, and the sales tax authorities had dropped the proceedings despite the payment of tax. So therefore, this mutually exclusive argument is still available under the GST context. Then one more decision of way to wealth. In this case, what had happened was there was a definition of business auxiliary, I think section 6519. It also referred to included commission agent who promoted or marketed goods. Now we were able to refer to some judgments, not in the context of service tax, other laws, bring out the proposition that goods, when it is IPO, what I have marketed is only, it is not at attained the stature of goods, therefore it cannot fall under business auxiliary services. This was later on affirmed by the Bangalore bench recently. Now when it came to right to use, transfer of right to use versus supply of tangible goods, you will find many decisions in the context of service tax law. To explain the proposition, we would always rely on certain judgments and the provisions of VAT law, particularly the RINL case, Rashtriya Ispat Nigam case. In fact, 2 days back, I think day before yesterday, there was one Supreme Court judgment which was rendered on this aspect, although I could not go through the full judgment on the very same issue where they say what is the distinction between transfer of right to use and supply of tangible goods. It is reported in TMI. Then ICU, in the context of central excise law, you had this related person fiction. In fact, much before the definitions were amended, the department tried to use it in the context of related party fiction, and the Supreme Court declined it in T.I. Mailer's case. Later on what they did, they amended the law and brought in the concept of ICU into that section 4 itself. So these are some of the past cases which I wanted to bring it to your notice. I will also point out as we go on the GST issues. Now why allied laws become important? GST law cannot operate in isolation, and if you ignore the other laws, the person would land himself in trouble. One instance which I have come across, there was a person who was seeking employment, a very senior consultant, software developer. When he went for the interview, the company asked him, do you want to be a consultant or an employee? So he blindly says, I want to be independent, etc., therefore I will be consultant. So they started deducting TDS under 194J. Now after many years, they receive a service tax notice, and even the company confirms that he is only a consultant. So therefore, taking decisions without looking at other laws is going to be a trouble. Similarly, the practitioner's knowledge would also be incomplete, in the sense you are advising someone, structuring a transaction, you are looking at GST law, but it may affect, let us say it is a foreign exchange transaction, it may affect them under the foreign exchange law or money laundering law or income tax law. Even if you don't specialize in that, at least you should be in a position to alert them that this is something important which you should look at. So that sense we should develop. Then without understanding of other laws, you cannot give effective solution or remedy. Then transaction has to be looked at from different perspective and for better compliance. Now, what are the important allied laws? Other law means any law other than GST which I have defined, but we will look at few of the laws and also point out instances where we have used this law in the context of GST. Now coming to the Constitution, for the last 6 years, we have seen so many cases which have gone to the courts, either the High Court or Supreme Court, and most of the cases are relating to the constitutionality of the levy, because Constitution is the supreme law, and you cannot advise someone. You may not get a solution under the GST law, but you can always bring about something in the context of the constitution and agitate the matter. There are, starting with transition issues, there are many cases which went to up to the Supreme Court. Then ITC eligibility, the Safari case is expected, judgment in Safari case is expected. Then validity of law, circular rules have gone to the high courts. Fundamental rights are affected, right to religion. For example, there is one case which we did in Kerala High Court, where under the Catholic faith, before the marriage happens, they are supposed to attend some course, and for that they have to pay some fees also, nominal fees collected. Now, the department would say that this is a service activity. So for this purpose, we have to research on Catholic marriage and the traditions and practices, and we were able to find out substantial substance on the aspect that this is nothing but a part of the religion. Therefore, by taxing it, you would be affecting the fundamental right of the person. The matter is still pending. They gave an interim stay in that matter. Some of the recent issues which have cropped up, one or two I will share. One is whether, if you look at Article 269A of the Constitution, which talks about the levy of IGST, if you look at the GST law, a question may come up whether IGST can be levied by the state. This is a very important issue. Because if you look at Article 269A, it would say levy and collection of IGST would be only by the Union, that is Government of India, and whatever is levied and collected would be apportioned between the states. Apportionment is different from assessment. Now the question is, all these IGST notices which have come from the state, is it valid in the first place? Because if you look at the expression levy, there is a Supreme Court judgment in National Tobacco case, a leading judgment. They would say that levy would include assessment. So once the Constitution mandates that the levy and collection would be only by the Union, the department, the State Department cannot usurp jurisdiction and levy tax. So this came up before the Karnataka High Court just before the vacation, and they have granted interim stay in the matter. And even if you look at the minutes of GST Council meeting, these issues have been discussed at length, and they have not been able to reach a conclusion on that. And Section 4 of the IGST Act, if you look at, has empowered through a notification only to handle refunds. So this issue is something which is of recent origin, which I wanted to bring it to your notice. Now, when it comes to contract law, there are so many principles which are borrowed while interpreting the GST law, because every supply involves some contract. Mr. Gupta was pointing out the clause relating to agreeing to obligation on all those case laws which he cited. So how do you construe that? It is based on the recitals in the agreement, and it is, suppose I enter into an agreement to not to compete in a particular jurisdiction or territory, then I am entering into an agreement for that purpose. Therefore, you can bring it within the clause. But if you look at a contract, as Mr. Gupta also pointed out, every contract also talks about breach and what is the consequence of breach, where damages are mentioned or compensation is mentioned. So you cannot take that clause in isolation and say that this is also a service, you are tolerating service. It is a very unfortunate trend that the department has caught on to this it started in service tax itself, and a day may come when they are exhausted of all these, whatever they could have thought of, they will use that related party fiction which is there in Schedule 1 and say husband is tolerating the wife daily, no consideration is required, you pay GST on that also. It may go to that extent. I will point out few other instances where this clause is unfortunately misused. Fortunately, the supply definition talks about furtherance of business. Otherwise, by now everyone would have landed up with a show cause notice. Similarly, the principles of Sale of Goods Act are borrowed on a day-to-day basis. In fact, if you look at the past, the development of works contract law, the initial thought process was that you cannot tax works contract which involves both goods and services. Because when you understand sale as per the Sale of Goods Act, it means transfer of property in goods, whereas this is a different creature. That led to the 46th Amendment in 1982. They brought in deemed sale to include all these aspects. Similarly, in the context of club or association, this controversy was there, because when you say transfer of property in goods from one person to another in a club, the club and members are one and the same. That YMIS judgment of the Honorable Supreme Court, which was also reiterated later on in this Calcutta Club case. So various principles are borrowed from the contract law. And we have had instances of where we look at transfer of property law. I'll give some instances a little later which I have noted down. Like what is immovable property, what is lease, what is exchange, what is transfer. Because the definition of service is so wide, means anything other than goods. Fortunately, they did not define goods as anything other than service. Otherwise, it would have been a disaster. Now it is very convenient for them. They say anything other than goods, therefore you pay tax. Highway authority wants to acquire my land. They say this is anything other than goods, therefore you are liable to pay tax. And they go to Schedule 3 and say this is not sale, this is acquisition of property. And you are receiving some amount also, which is the consideration. So these type of, to interpret these type of issues, you may have to take the support of other laws. One thing which I want to say before I proceed further is, to start with, even if you don't read any other law for the time being in force, at least read this 1897 Law, General Clauses Act. You will find that most of the provisions which are there has some link with the GST law. You can, for example, let us say today is Saturday. You wanted to file an appeal manually, let us say. The department is closed. And on Monday, if you send your person, can the officer say, last day was Saturday? You should have come on Friday itself. Therefore, you file a condonation application. That provision you will find in General Clauses Act. Similarly, there are various definitions. For example, person is defined in the General Clauses Act. In the service tax law, prior to the negative list regime, you didn't have a proper definition. So we would look at General Clauses Act. I remember some litigation where the government services were subjected to tax. We would also interpret saying that if you go by the General Clauses Act, you cannot bring government within the purview of the definition of person. It's a sovereign power. Later on, if you see, the law was amended, they introduced a specific definition in the service tax law, which you will also find it in the context of GST. So there's one more thing which we often refer. There's a definition for document, there's a definition for offense, and there are many other. Section 6, one example which I gave was on right to appeal. That comes from General Clauses Act. In fact, I remember addressing a gathering during this before this corona period, where we spent about 2 or 3 hours only on General Clauses Act. It is so important. So therefore, I would recommend that you should pick up this old law and read it, at least after attending today's session. It will be of use. Goods and services excludes securities. But if you go to the securities definition in GST law, they direct you to SCRA. So therefore, you are required to know what is securities definition under that law and the case law development there. SEZ Act has a lot of link with the GST law. Even in the past it was so. For example, when you look at zero rated supply, you are supposed to interpret the SEZ provisions. There was a lot of litigation in the past where people had availed some exemption, but they would not have fully adhered to the procedures. In that context, we were able to use SEZ law because there is a provision which would say SEZ law overrides all other laws. So we will say, we would take an argument that since that law overrides all other laws, whatever procedures you have put in the service tax law to claim exemption should be ignored because this law will override. There are tribunal decisions on that aspect agreeing to this argument. Therefore, SEZ also becomes very important. Similarly, foreign trade policy, various schemes and the benefits which are announced by the government come under the foreign trade policy, which is Ministry of Commerce. So there is an interplay with taxation also. Then Customs Act, I will come to that a little later. I'll just list down the laws and later on go to instances. Customs Act and Customs Tariff Act. So section, if you look at the IGST law, in case of import of goods, you don't apply the GST law. You go by the valuation and the point of time also it is based on the customs law. So it is linked to the customs law. But one thing which has been bothering me for some time, which I have also discussed in other forums, and this issue has been debated by others also, is that the taxable event under the customs law is different from GST. So in the context of customs, whether you purchase the goods or it comes free, it doesn't matter. The customs law is triggered. Whereas in GST law, when you want to apply the IGST provisions, a question may crop up. Suppose somebody sends goods to me free. Let us say it's from an unrelated person. Can you still apply GST on those type of transactions? I have seen this is, as of now, people are taking a conservative view as long as credit is available. When you take credit, then this issue need not be agitated. So this is something which is bothering me. I am yet to find a solution on this aspect. Then RERA, after 1/4/2019, if you look at the provisions relating to the real estate sector particularly, it is all linked to the RERA. Who is a promoter? You have to look at the definition of RERA. Then you should also, what is REP, RREP, etc., because the rates depend on that classification. So it has a link with RERA. About 3 days back, I received a call from a chartered accountant in Hyderabad. The question was this: sir, there is a JDA, Joint Development Agreement, where there is a landlord and also a developer. That person's client enters into a power of attorney sort of arrangement with the landlord to sell those plots or they sell those units by taking over. So the question came, whether I can also call myself, the client can be called as promoter under the, for the purpose of applying the benefits under the GST law. So my first question to her was, what is the stand taken by that person under the RERA? Is he registered as a promoter? Then she said, no. They have taken a clear stand, they are not promoter. Then I told, although they borrow that definition, your stand under the RERA also matters. Therefore, unless you get a registration there, you will not be entitled to claim yourself as a promoter under this law. So there is always a link. You cannot stick to GST, you have to look at other laws also. Similarly, the insolvency code, that also came along with GST. For example, under the insolvency law, you have this moratorium period. When the CRP is admitted, when the resolution plan is admitted or the application is admitted for resolution, they bring in what is known as moratorium. During that time, can the department proceed against those parties? These issues have cropped up. So there are judgments, which I will come to it a little later. I have kept it in the slide. Similarly, what happens to government dues? Let us say the party goes into liquidation or resolution under the IBC. Government, does it get its dues? Are they secured creditors or they have to wait in the queue? There is something called as waterfall mechanism under the IBC law. Should they also stand in the queue? These issues have cropped up. Therefore, it becomes important. This one more law, 1974, Economic Offences Inapplicability of Limitation Act, 1974. This is a very crucial law, particularly when there is prosecution. What this law would say, there is a schedule in that law. I think this is one of the shortest law which I have ever come across. It has hardly few provisions in that. What this law would say is that when there is an economic offense, whatever laws are listed in the schedule, the limitation would not apply. You see that law, you will have all these laws like central excise, service tax, all the tax-related matters mentioned there. I was curious to see whether they also amended it to bring in GST. It is there. So therefore, when someone, you cannot say that a person can get away by an offense under the GST law, because this law says limitation does not apply. So it is like a Damocles sword which is hanging. That doesn't mean that they can commence proceedings at any point of time, maybe after 15 years, 20 years. The answer is no. There is something called as reasonable time, as interpreted by the courts in the past, that can come to the rescue. Similarly, there is a lot of interplay with the company law also. In fact, in the GST law, there is one chapter. Generally, we miss out reading those provisions. If you look at the chapter liability to pay in certain cases, chapter 16 of the GST law, which starts from 85 onwards, this goes against whatever principle which is laid down in some of the general laws like Partnership or Companies Act, etc. For example, if a person, let us say the company goes into liquidation, how does the liability work? GST law in section 88 talks about it when a company goes into liquidation. Similarly, 89 would also say liabilities of directors of a private company. The general understanding is corporate will, separate personality, Solomon and Salomon, etc. But this GST law would say, section 89, the directors will be personally liable. So you are giving a go-by. Unless they are, the burden is cast on them, that they have to prove that there is non-feasance or there is no non-feasance or misfeasance, etc., or breach of duty on their part. Then similarly, when it comes to the partnership, there is a clause, section 90 section would say that in the case of, let us say a partner retires from the firm, he would have taken all steps under the partnership law. But look at the proviso which is there in section 90. It says, where any partner retires from the firm, he or the firm shall intimate the date of retirement of the said partner to the commissioner. Which commissioner? Our GST commissioner. By a notice in that behalf in writing, and such partner shall be liable to tax, interest or penalty, etc., up to the date of his retirement. So there is an additional burden which is cast. So these type of, and similarly you look at section 93, a person dies. You all remember there was one judgment of the Supreme Court in the context of excise law, Shabina Abraham's case, where the Supreme Court said that you cannot issue a notice after the death of a person. The case also dies with him, because section 11A would say person chargeable to tax, which we also used in the context of service tax, section 73, person chargeable to tax. In GST also, this expression person chargeable to tax is there, but this provision 93 becomes important. It says if a business is carried on by a person is continued after his death by his legal representative, then that person becomes responsible. And most important thing, probably to overcome this Shabina Abraham, is that whether such tax, interest or penalty has been determined before his death but has remained unpaid. That means there is a possibility where they would say that we will determine the tax although he has died. But still, based on 73 and 74, it is still possible to argue that you should have issued notice to the person chargeable to tax. So these type of interpretations have also cropped up, and there are specific provisions which according to me should be kept in mind, because the general law has to pave way for the special law. Then Limitation Act 1963 is also important. One judgment which I saw, I think a month back, where they applied the provisions of section 5 of the Limitation Act in a case where the appeal was beyond the condonable period. They applied that section 5 of the Limitation Act and said that the appeal can be condoned, the lapse can be condoned, despite the fact that the Supreme Court, in the case of GlaxoSmithKline, the Supreme Court says that even the writ court cannot condone something which is prescribed in the law. And earlier to that you had all these Singh enterprises. So this debate has been going on for a very long time. And before this Glaxo case was decided, the Karnataka High Court, where Justice Jayant Patil rendered few judgments saying that the writ court has the power to condone the delay beyond the period which is prescribed under law. So when it comes to appeals, we should be very cautious in advising the client, because these judgments may come in your way. And one stray judgment which I pointed out is, I also put the citation, the slides will be made available. So this Limitation Act has been applied there. Indian Evidence Act, what is a fact? What is a relevant fact? What is fact in issue? What is evidence? What is documentary evidence? So these, although the strict rules of evidence don't apply in GST context, it is relevant to know that for the purpose of leading evidence in matters. I should plead ignorance of those new laws which have been enacted. Even the title is little complicated. I was standing outside in that bookstall and trying to register. Still there is a confusion. So I managed to frame an acronym, BNS, or there is one more, BNSS, Nyaya Samhita, something like that. So that also will become an allied law. So you cannot ignore that. Although I think it may come a little later, though it is enacted. Now IPC is very important. Summons are issued. How many of you have seen summons? Many of you would have seen, which your clients have given. Generally, the summons contain words such as they abstract all these provisions. You cannot leave without our permission. You are supposed to come at 10:30. If you don't come, it will be an offense. If you don't answer question, they also give an annexure of those provisions. So this IPC, refusing to answer a question, may become an offense under IPC. Obstructing a public servant is an offense under IPC. Or threatening him may become an offense under IPC. Summons, if you jump summons, that may lead to proceedings under IPC. Of course, there are also provisions specifically brought into GST law to take care of this aspect, but prosecution is possible under IPC also. So you cannot even ignore IPC, falsification of accounts, fabrication of evidence, IPC. And now you will have a new law. I do not know how they have been able to bring out the new law. I am yet to go through it in depth. Central excise, sales tax and value added tax have been repealed. But according to me, it is still allied, because many of the concepts and the law which has evolved in the context of those laws can be still borrowed into GST regime. One instance which I pointed out was relating to levy of IGST by the state. Some of you may have a doubt. CST also was on same lines. How did state come into the picture? If you look at 269 of the Constitution, the words are different. It said levy and collected, but assigned to the states. Here in GST, levy and collected, but apportioned, and apportioned, that is different. And section 9(2) of the CST Act, they had borrowed the entire mechanism of VAT law or sales tax into CST. Therefore, that was assignment, and here it is not so. So see, those concepts, in fact, I had to read the commentary which of Pithisarya on CST to understand how the law evolved. There is a lot of case law development on that aspect. So therefore, don't think that just because the old laws have gone, you can forget it. Particularly if you are litigating, you always remain in the past. You don't live in the current. Present is always, today's present is tomorrow's past. So